And it's a great opportunity for you to learn European intellectual property law with the most renowned guest lecturers and the professors. You can find more information on our website, and if you're interested in applying, you can do it now on universityadmissions.se. Applications are open until the 15th of January. If you also have any other doubts, you can follow us on our social media. Among one of those great opportunities is the opportunity of being part of the intellectual property review, the one Riana and I are participating and are co-chief editors. And she will explain you a little bit more about what our review is about.
Thank you, Alex. So the Stockholm Intellectual Property Law Review is a student-led journal of legal scholarship with a focus on European intellectual property law. The purpose of SIPLR is to create an academic legal forum where the most influential and significant topics of IP are discussed by students, scholars, and lawyers alike. The Law Review is published twice a year, in June and December, with volumes available in both physical and electronic form. This year, our team includes Alexandre Miura, Anne Bunda, Nini Janishvili, Palin Lee, Pia Leonardo Remen Schneider, myself, Riana Harvey, and Valentine Laboom. One of the articles that will be in our December issue is our interview with our keynote speaker, Lord Justice Arnold, where we discussed both the topic of today's seminar, as well as got insightful views on current intellectual property rights issues and experiences from his career. The journal's December issue will be available by the 18th of December on our website, www.stockholmiplawreview.com. There will also, as usual, be an opportunity to order a printed copy of the journal. I'll now hand back over to Frantzeska. Thank you.
Thank you so much. As you have seen, we have a very intensive schedule today. But we will have time for questions and a short discussion after the presentations. So please write your questions by using the chat function, and we will do our best to discuss them all. My colleague also, Hellstadius, will help us promote the questions to the speakers. If you have any technical issues, please use the chat as well. And with that being said, we welcome our keynote speaker, Lord Justice Richard Arnold, to start. Sir Richard Arnold is a judge behind the most well-discussed cases in the field of blocking injunctions, including the first ever granted UK order in a trademark case, the Cartier case, the first ever granted UK order in a TPM case, the Nintendo case, and the first ever granted UK live blocking order, the FAPL cases. Lord Justice Arnold, thank you so much for having the time and possibility to be here today. Welcome to start.
Thank you very much for the invitation to speak to you, and good afternoon, everybody. So let me begin by sharing my presentation. So I'm just trying to get it into slideshow mode. Sorry, I'm having a little bit of trouble with the Zoom functionality. Okay, there we go. So, have you all got the right screen?
Yeah.
So, okay, so I'm going to be talking this afternoon about the state of the art with respect to website blocking and streaming server blocking. I hope you've got on your screen a slide headed overview, which sketches out what the subjects I'm going to be talking about in this presentation. So first of all, I'm going to be talking about the concepts of primary, accessory, and intermediary liability. Secondly, the legislative basis for intermediary liability in the EU and the UK. Thirdly, the current position in England and Wales with respect to website blocking injunctions. Fourthly, the Cartier case in the Supreme Court on the question of who should pay the costs of implementing such orders. Fifthly, the extension of website blocking injunctions to non-IP cases. Sixthly, injunctions requiring ISPs to block streaming servers. And then that will take me on to discuss the diversity of practices and outcomes around Europe on these subjects, and finishing up with the need for a more harmonized international legal framework. So we need to begin in this field by defining our terms and recognizing the different concepts which are involved. And in my view, it's very important to distinguish between primary liability, accessory liability, and intermediary liability. What do I mean by those terms? Well, primary liability is the legal liability of the primary infringer of an intellectual property right. By contrast, accessory liability is the legal liability of an accessory to an infringement of an intellectual property right. So not the person who actually does the infringing act, but someone who insists or otherwise participates in the infringement. And it's worth noting that in English law, accessory liability is non-statutory. It's not provided for in any of our legislation, with the small exception of authorization in copyright. And therefore, what the judges have done over many years is to fill that gap by applying the common law doctrine of joint tortfeasance. Now, all of that is well established. What is much newer, certainly so far as most of European law is concerned, and certainly so far as English law is concerned, is the concept of intermediary liability. Now, this is something different again. And by intermediary liability, I mean the liability of intermediaries to injunctions to prevent or reduce infringements by third parties, even though the intermediary is not legally liable as a primary infringer or as an accessory. So this is a very special kind of beast. It's quite different to what we are normally dealing with in the law. And one can see these differences in the fact that primary and accessory liability deals with your liability for damages for past acts and injunctions for the future, which will usually be prohibitory, that's to say negative in form, stopping you from doing something. Whereas intermediary liability is not about damages for the past, it's purely about injunctions for the future, and the form of such injunctions are usually mandatory in nature, that's to say they're positive injunctions requiring you positively to do something. So, against that background, we turn to consider the legislative basis for intermediary liability as I've defined it in the EU and in the UK. Now, so far as the EU legislation is concerned, we start with the InfoSoc Directive from 2001, and I've put on the screen the key recital for this purpose, which is recital 59. And what that tells us is that in the digital environment in particular, the services of intermediaries may increasingly be used by third parties for infringing activities. In many cases, such intermediaries are best placed to bring such infringing activities to an end. Pausing there, what did the EU legislature mean by that statement that intermediaries are best placed? Well, you can interpret it in two ways. One way is purely from the point of view of practicality. If you're trying to stop infringements in the digital environment, then the most practical way forward in many circumstances is to try and get an intermediary to do it. Another interpretation of this is that it's based on the economic theory of lowest cost avoidance, which many people subscribe to, but is nevertheless still somewhat controversial. But anyway, I don't have time to get into the economics today, but it's worth looking up if you're interested in. And what recital 59 goes on to say is that for those reasons, right holders should have the possibility of applying for an injunction against an intermediary. And notice that recital 59 finishes by saying that the conditions and modalities relating to such injunctions should be left to the national law of the member states. So against that background, Article 8.3 provides that member states shall ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe a copyright or related right. And in the UK, we transposed that, we implemented it by an amendment to our Copyright Designs and Patents Act 1988 to insert a new section 97A, subsection 1 of which says that the High Court shall have power to grant an injunction against a service provider where that service provider has actual knowledge of another person using their service to infringe copyright. You will notice that the terms of that provision are different to those of Article 8.3, in particular because of the reference to actual knowledge. But for reasons that will appear, that doesn't actually make any substantive difference to the way the law operates. So the next provision we need to look at is the Enforcement Directive from 2004. And again, we've got recital 23 here, which is in very similar terms to recital 59 of the Infosoc Directive, as we looked at before. And then on the basis of that, Article 11 of the Enforcement Directive says that member states shall ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe an intellectual property right. So essentially a parallel provision to Article 8.3 of the Infosoc Directive, but this time extending to all intellectual property rights and not just copyright and related rights. Now, whereas the United Kingdom specifically implemented Article 8.3 of the Infosoc Directive by an amendment to the Copyright Act, as I've shown you, when it came to implementing Article 11 of the Enforcement Directive, for reasons that have never been explained, the government took the view that it didn't need to do anything and that UK law already complied. As it turned out, they were proved correct, but nevertheless, it's still slightly strange that it was thought necessary the first time around to have a specific statutory amendment, but not the second time around. So, current state of the play in England and Wales following the Cartier and Sky case can be summarised as follows. The first injunction requiring ISPs to block access to websites facilitating infringement of copyright was granted by me as long ago as 9.5 years ago, back in the summer of 2011. I find it quite staggering that nearly 10 years have passed since then. And that was in a case called 20th Century Fox and British Telecommunications, or BT, known as Newsbin 2 for short, that being the name of the website that was involved. And it was very much a test case at that point in time, and I gave permission to appeal both to the copyright owners and to the ISPs, but slightly mysteriously to me at any rate, no appeal was pursued. And following that case, injunctions were granted in another 15 copyright cases against over 250 websites, all on applications which were unopposed by the internet service providers. Then along came the Cartier and Sky case, which was the first time that it was tried to extend this to a situation of enforcing trademarks. This was Cartier looking to get blocking orders against websites that were supplying counterfeit Cartier merchandise. And again, this came before me, and I granted the injunction against the websites in question, of which there were a number. And again, it was something of a test case, and again, I gave permission to appeal, and this time, the appeal was actually pursued. And the ISP has appealed against the injunction to the Court of Appeal, and then subsequently on the costs only to the Supreme Court. And the overall effect of the decisions of the Court of Appeal on the Supreme Court was to confirm the jurisprudence that had been built up at first instance in copyright cases since 2011, save with regard to the costs of implementation. So the the case law establishes that the courts of England and Wales have jurisdiction to grant website blocking injunctions to combat trademark infringement and by implication any other IP right, despite the absence of specific implementation by the UK of the third sentence of Article 11 of the Enforcement Directive. And when the case got to the Supreme Court held that our courts had this power applying ordinary principles of equity, which is another area of judge-made law, regardless of European law, as it was put by Lord Sumption, who delivered the judgment. Orders for the disclosure of information, which was an established category of order in our courts, are only one admittedly common category of order in which a court may make against a third party to prevent the use of his facilities to commit or facilitate a wrong. So that was recognized as being a general principle and therefore applicable in this situation. And that's why it turned out that the UK government was correct when it came to implement the InfoSoc directive, that it didn't need to do anything, even though it had thought it needed to do something when implementing the InfoSoc directive. The court's jurisdiction on that basis is adequately prescribed by law, because that's a recognized principle in our law. And the threshold conditions for the grant of such an injunction are four in number. Firstly, that the defendants are intermediaries. Secondly, that the users and or operators of the website are infringing the claimant's IP rights. Thirdly, those users and or operators are using the defendant's services to infringe. And fourthly, the defendants have actual knowledge of this, which may be as a result of being notified by the right owner. And if you look at those threshold conditions, the first three come out of the language of Article 11 of the Enforcement Directive. The fourth one doesn't, but it comes out of the provisions of the e-commerce directive, which I don't have time to go into, but in particular the prohibition in Article 15 on general monitoring, and also the qualifications to the safe harbours contained in Articles 12, 13 and 14. And the cumulative effect of that is to imply a requirement of actual knowledge. Assuming that the four threshold conditions are satisfied, the court then needs to go on to consider whether it's appropriate in the circumstances of the particular case to grant an injunction. And in order for an injunction to be granted, it must be firstly necessary, secondly effective, thirdly dissuasive, fourthly not unduly costly or complicated, fifthly avoid barriers to legitimate trade, sixthly strike a fair balance between the fundamental rights engaged, seventhly proportionate, and eighthly safeguarded against abuse. Where do those criteria come from? Answer: all but one of those come from the language of Article 3 of the Enforcement Directive, which sets out those various criteria for the grant of remedies in the intellectual property context. The exception is number 6, striking a fair balance between the fundamental rights engaged, and that criterion comes from a long list of decisions of the Court of Justice of the European Union, and in particular the case of L'Oréal and eBay, where I was the referring national judge. If you work through those criteria systematically, what you find is that of those 8 factors, proportionality is the key one, since consideration of all the other factors feeds into the proportionality analysis. Now, in considering the proportionality of such an injunction, an important consideration is the nature of the technical measures which the ISPs are required to adopt, and hence their efficacy, costs and impact on lawful users. And the practice in England and Wales ever since the first order back in 2011 has been to require these technical measures to be specified in detail in the court's order. And that is not the case in some other EU member states, for example, Austria, and I'll come back to that point later. Although these injunctions are quite easily circumvented, it doesn't follow that they're ineffective. On the contrary, the evidence that has been accumulated over the nearly 10 years since the first one was granted shows that they are effective in reducing traffic to targeted websites. Whether the extent of that reduction warrants the costs of the injunction, if and to the extent that they are borne by the ISPs, is a question of proportionality. And in Cartier, there was a lot of argument put forward by the ISPs about the availability of alternative measures which could be used to combat the trademark infringements that were the concern of the trademark proprietor in that case. But neither I nor the Court of Appeal on appeal were persuaded that the various alternative measures that have been proposed would be as effective as a blocking order implemented by the ISPs. And that was a key reason why both I and the Court of Appeal came to the view that a blocking order was indeed proportionate. An important practical point about the way we do things in England and Wales is that the orders enable the right holders to notify to the ISPs any other IP address or URL, as the case may be, whose sole or predominant purpose is to provide or facilitate access to the target website, which must then be blocked. And if you think about it, you will soon realize why that's important, because otherwise, if the court makes an order requiring a specific IP address or URL to be blocked, and you can't update that, then it will be, the order will be circumvented in a matter of minutes, because the pirates will just change the relevant IP address or URL. And so for these orders to be effective, they have to be regularly updated. And that's the way in which it's achieved in England and Wales. It is very important, for the reasons that I touched on earlier, to have safeguards against abuse in orders of this sort. And over time, we have incorporated a series of procedural safeguards in the orders. The ISPs can apply to set aside or vary the order in the event of a change of circumstances. Users can apply to set aside or vary the order. Website operators can apply to set aside the order. Information about the block must be displayed at the target address. And there is a sunset clause, that is to say the order expires after a period of time, and therefore if the right owner wants it to be continued, they have to come back to the court to get it renewed and justify it being renewed. Another important practical point is that, unlike in some other member states, for example, Germany, under our law, there is no requirement for the right owner to sue or attempt to sue the website operators first, or even to prove that it would be pointless for them to try. So that takes me to my fourth topic, which is the issue which exercised our Supreme Court in the Cartier and Sky case. Which was the question of who should pay the costs of implementing a website blocking order. And the practice that had been adopted by the High Court in the cases prior to Cartier and in Cartier itself was to order the right holders to pay the costs of an unopposed application. So in other words, the right holders would have to pay the costs of gathering the necessary evidence, putting that evidence together, putting it before the court, and persuading the court that this was an appropriate case in which to grant an order. And then to pay the costs, order the ISPs to pay the costs of implementing the order if it was granted by the court. And if the ISPs unsuccessfully opposed the application, then of course they would pay those costs in addition. In the Court of Appeal, that practice was upheld by a majority of the court, and they gave 5 reasons for upholding the order for the ISPs to pay implementation costs. Firstly, they said that Article 11 of the Enforcement Directive gave the right holders a legal right to an injunction against intermediaries in appropriate circumstances. Secondly, Article 11 was part of a larger scheme giving ISPs immunity from infringement claims and from general monitoring. That's by virtue of Articles 12 to 15 inclusive of the e-commerce directive. Thirdly, they took the view that recital 23 of the Enforcement Directive supported that conclusion. Fourthly, they thought that the decisions of the CJEU in the L'Oréal and eBay case that I mentioned earlier, and then in the later UPC and Constantine case, supported this conclusion. And fifthly, unlike in our domestic case law on disclosure of information to which I referred earlier, which is known by reference to a case called Norwich Pharmacal, the proceedings in these cases were not preparatory to infringement proceedings. In other words, if you have a case where you're seeking information about people who are infringing your rights, the reason why you want to find the information is in order to bring legal proceedings against them later. But in this context, that's not so. The website blocking orders against intermediaries are an end in themselves. They're not preparatory to some later proceedings against ultimate infringers. So those were their reasons for upholding that order. However, when it got to the Supreme Court unanimously disagreed. And they held that the right holders should pay the ISP's marginal costs of implementing and updating the injunction. So that was the extent of the disagreement. Otherwise, they agreed with the lower courts that the ISPs should bear the costs. So the practical result of that is that the ISPs have to pay all the capital costs of having the necessary infrastructure to implement website blocking injunctions. But the marginal costs of implementing and updating any particular injunction is to be borne by the right holder. And their reasoning was as follows. They read recital 23 differently. They focused in particular on the last sentence about conditions and modalities being left to national law. And they said, well, that means that the costs of implementation are a matter of national law. Secondly, they thought it was absolutely critical that the ISPs were innocent parties in the sense that they weren't primary infringers, nor were they accessories. So the only liability that was in play was what I've called intermediary liability. And they thought that there was a close analogy with various domestic principles, one being the Norwich Pharmacal principle that I've referred to already about getting information about infringers, an analogous type of situation called banker's trust, which is all about getting information about bank accounts, and freezing orders, where you're freezing people's assets. And in all of those three contexts, it's well established under our domestic law that the compliance costs of innocent parties are to be paid by the applicant, but then can be recovered from the ultimate wrongdoer in subsequent proceedings. And they thought there was a close analogy, even though in this context there never are any subsequent proceedings against the ultimate wrongdoers. Two factors which were not considered by the Supreme Court in their judgment, presumably because they weren't raised in argument, are that ordering ISPs to pay implementation costs has two practical advantages. Firstly, it avoids the need to quantify incremental costs and hence evidence and argument on that issue. Secondly, it gives the ISPs an incentive to be efficient, to innovate, and to cooperate with right holders. But as I say, that doesn't appear to have been, those factors don't appear to have been raised in argument and hence were not considered by the Supreme Court in their judgment. So, my next topic is the extension of website blocking injunctions to non-IP cases, and this is the Nintendo case that was mentioned earlier. Now, you'll recall that we started with Article 8.3 of the InfoSoc Directive, which implemented intermediary liability in the context of copyright and related rights. Then Article 11 of the Enforcement Directive generalized that to all IP rights, but in the European legislation, there's nothing that goes beyond IP rights. So what happens if the complaint is one of infringement of a non-IP right? And this was the issue that arose in the Nintendo and Sky case. And what happened here was that I granted a website blocking injunction on the application of Nintendo, requiring ISPs to block access to 4 target websites, which were advertising, offering for sale and selling devices and software for circumventing the technological protection measures protecting Nintendo Switch video games consoles. And in support of their application, Nintendo relied partly on EU trademarks, and that of course didn't cause any difficulty because they could rely on the Cartier precedent there, but partly on rights conferred on Nintendo pursuant to UK implementations of Article 6 of the InfoSoc Directive and Article 7.1 of the Software Directive against advertisers and so on of circumvention devices. And Nintendo accepted that its anti-circumvention rights were not IP rights within the Enforcement Directive. I mean, they might have raised the argument that actually there's no definition of IP rights in the Enforcement Directive and that these rights were covered. But they didn't choose to run that argument. They accepted that these were not IP rights. And what they said was, well, that doesn't matter. Look at what the Supreme Court said in the Cartier case. We have jurisdiction under our domestic law to grant website blocking orders, even if the rights that are being enforced are not IP rights. And in the light of what the Supreme Court said in Cartier, I accepted that argument and held that the High Court had jurisdiction to make the order, and duly made it because it was appropriate on the facts of the case. Another development which has occurred since this jurisdiction was originally established is, again, one that was mentioned earlier. And this started 3 years ago in 2017. And starting with a case called FA Premier League and BT in July 2017, a series of orders have been made requiring ISPs to block the IP addresses, not of static websites, but of streaming servers which are being used to stream infringing copies of live broadcasts of Premier League and UEFA football matches and boxing matches. And the way these orders work is that they set out criteria, some of which are confidential, for compiling on a rolling basis a list of servers to be targeted. And that gets updated on a regular basis. And the interesting thing about these orders is that by the time the first one was made, the technology had got to the point where you could turn on a block at the start of a match and turn it off at the end of the match. And so the orders only provide for the target servers to be blocked for the duration of the match. So it's highly targeted and therefore highly proportionate. In addition to the usual safeguards in website blocking orders, the hosting providers which host the targeted servers have to be notified of the order, and they too can apply to set it aside. And since the original one, which was concerned with Premier League football matches, a series of other orders have been made, all concerned with live sporting events, UEFA football matches, boxing matches, and so on. And the evidence filed in support of later applications indicated that the earlier orders had been very effective. Nevertheless, there have been circumvention attempts which have led to the orders needing to be modified occasionally to ensure continued efficacy. By agreement of the parties, following the decision of the Supreme Court in Cartier and Sky, the orders contained no order as to costs. There may have been some private agreement between the parties as to costs, but if so, it wasn't revealed to the court. Those of you who are followers of the wonderful IPCAT blog will have seen that earlier this week there was reported the latest chapter in this particular aspect of the story, which is that in one of these cases, which is a case called Matrim, the order had come to the end of its sunset period, and so there'd been an application for a further order to be granted, and Mr. Justice Burse decided that he would grant a further order blocking streaming servers, infringing streams of Matrim's boxing matches. And there was some discussion in his judgment about the question of confidentiality, which he maintained, and the terms of the order. So it doesn't change anything, but just provides you with the latest state of play. What we see if we look around Europe is that there is a considerable diversity of practices and outcomes with regard to website blocking injunctions. And let me give you some examples. A first example is the courts in some countries, such as Germany, require right holders to try to sue the website operator first, or at least prove that it would be pointless to try, whereas others, such as my own, don't. Secondly, courts in some countries specify the technical measures to be adopted, while others leave it up to the ISPs to decide what technical measures to employ. And we are in the first category. Austria is an example of a country in the second category. And I think partly for that reason, courts in different countries take different views on efficacy and proportionality. My personal view on that subject is that I don't know how a court can assess proportionality unless it knows what technical measures are going to be implemented. Whenever I've taken a decision on proportionality in this context, I've known what the technical measures are. I've therefore been able to form a view on such questions as overblocking, and I've therefore been able to form a view on proportionality. I just don't understand how you can properly do that if you don't know what the technical measures are. And I suspect that that has some explanation for the different outcomes on that subject. And this is illustrated by my fourth point, which is that courts in some countries have granted website blocking injunctions targeted at the Pirate Bay, and that's been more and more countries around Europe as time has moved on. But there are still one or two countries that have so far refused such injunctions, although, as I say, as time moves on, they become a shrinking minority. Now, some of these differences are inevitable due to different national legal systems and procedural laws, but others are not. And I would identify three key reasons for the differences as follows. Firstly, differing national implementations and interpretations of Article 8.3 of the InfoSoc Directive and Article 11 of the Enforcement Directive, which have so far only been partially breached by the various judgments of the CJEU in cases like Scarlet Extended and UPC and Constantine. Secondly, there are, of course, the continuing difficulties with the concept of communication to the public, and in particular the circumstances in which hyperlinking and similar acts can be an infringement of copyright. Of course, we've had plenty of CJEU decisions on that subject, like GS Media, Filmspeler, Pirate Bay, but even so, the topic still causes problems. And then importantly, thirdly, the absence of any harmonization across Europe of accessory liability, which was, of course, the subject of question 2 in the Bryan and Zigo case, the Pirate Bay case. And the Court of Justice circumvented that by, on one view of it, importing questions of accessory liability into the primary liability issues that they were dealing with in question 1. But of course, if we did have harmonisation of accessory liability for IP infringements, matters would be simpler. And my conclusion, therefore, is that if greater consistency is to be achieved, a more harmonised legal framework is required. And a first step would be to do that at European level. But more generally, this is an international problem because, of course, website blocking is not something one wants to have just in one country or even one region. If you're really going to be effective about website blocking, you need a global solution. So that requires an international legal framework. And a first step would be a more harmonized legislative basis for injunctions against intermediaries whose services are used to infringe intellectual property rights, such as specifying more clearly who is an intermediary for this purpose, the threshold conditions to be satisfied, and the essential procedural requirements, such as whether you have to bring a claim against the ultimate infringer or not. A second step would be a more harmonized basis for the underlying claims for infringement. And since most of the claims to date concern copyright infringement, this would mainly relate to copyright and in particular communication to the public. A third step would be harmonization of the rules on accessory liability for IPR infringement. So there we go. That is my overview of the current state of play so far as this subject is concerned. Thank you for your attention, and I'll try and answer any questions you may have later.
Thank you very much, Sir Arnold, for this very interesting and informative presentation. And we will come back to that during the discussion and the questions. In the end of this session, in the end of this seminar, I propose we move forward directly to our next speakers, which are Karin Cederlund, who is partner and attorney at law at the law firm Sandart and Partners, and Stefan Johansson, who is a judge at the Patent and Market Court at the Stockholm District Court. Karin and Stefan will discuss the Swedish approach to website blocking injunctions.
So we're going to make sure you get the PowerPoint presentation here first. Vi ska den finns även på den.
Där.
Ja. Make a new attempt here.
Där.
Yes, now it works. Thank you.
Perfect. So sorry for the delay, and thank you very much, and thanks to Lord Justice Arnold for a very interesting presentation. In Sweden, we have not yet had that many cases on website blocking. In fact, there's only been 3 cases so far. I will try to give some idea on why that is the case before I comment on the specific cases. First of all, just as Lord Justice Arnold mentioned, it all began with Article 8.3 in the Infosoft Directive. When Sweden was planning to implement this provision, measures such as blocking or filtering were not used at all, not even for crimes such as terrorism or child pornography. And I think it's fair to say that for most politicians, they had doubts about introducing such measures for copyright. The focus was on the infringer, how to deal with him or her, and how to remove the content rather than preventing access. So when the government looked at the directive, and in particular recital 59 mentioned by Lord Justice Arnold, the focus was on the last sentence. The conditions and modalities relating to such injunctions should be left to the national law of the member states. Based on this sentence, the Swedish government took the view that it was not necessary to introduce or to make it possible in all cases for right holders to obtain injunctions against intermediaries. There was some flexibility in this respect left to the member states. So the way this was done in the Swedish legislation was that the general provision on injunctions were slightly modified. So instead of only being able to issue injunctions against infringers, it was explicitly added that injunctions can also be issued against anyone who contributes to an infringement. And that was the way Article 8.3 was transformed into the legislation. So we are talking about something more similar to the accessory liability mentioned by Lord Justice Arnold before. However, it was not necessary that you could actually be held liable. Intent or negligence was irrelevant, and it did not matter if you were protected by a safe harbour according to the e-commerce directive. You could still face an injunction. So this was the actual provision in the copyright law in Sweden. In the preparatory works, the government drew parallels to aiding and abetting from criminal liability, and pointed out or said that it was not enough that the intermediary offered the service. However, to contribute, one example where contribution might be at hand is when the infringer has entered into an agreement with the ISP, and his service is used to commit infringements. And if the ISP has received concrete indications that this is the case and still continues to provide the service, then he or she is contributing in this sense. At the same time, the government recognized that ultimately it's the European Court of Justice that decide how the directive is to be interpreted. That led to a situation where the first years after the implementations of the Infosoft directive and the enforcement directive saw other types of measures, in particular criminal sanctions. They were focused on specialized police officers and specialized prosecutors trying to target this kind of crime. The right to information was introduced and made it possible to reveal the identity of infringers, including end users. And the injunctions, they were mainly used, because there were quite a few decisions where the injunctions against intermediaries, this provision was used, but that was only relating to ISPs that were providing their services for the infringers. For example, ISPs providing internet access to the Pirate Bay or several or trackers relating to the Pirate Bay or used by them. These ISPs were ordered to stop providing the internet access. And another way of dealing with infringements was that in criminal cases, the domain names could be forfeited to the state. So basically, the state took possession of the domain names. So this was pretty much it. And it was not until 2015 we saw the first claim for website blocking in Sweden. That concerned blocking users' access to Pirate Bay and SVFilmer, which was a streaming site. This first claim was rejected by Stockholm City Court. the basic arguments was that the implementation that had been done by the Swedish government was in line with the directive, and the ISP in question was not contributing in the way required by Swedish law. So basically, we had a situation where you could target sites such as Pirate Bay or Svefilmer, or for that, even other private persons committing serious infringements. You could also target their ISPs in order then to block their access to internet. To the extent end users were committing infringements in other ways, you could target the end users, of course, as well. But the one on this slide called ISP2, the ISP giving internet access to end users in general, they could not face injunctions according to this, and they are of course the ones that could implement blocking measures. However, this judgment was appealed to the Patent and Market Court of Appeal, and this court came to the conclusion that under EU law, member states are obliged to provide the possibility to issue injunctions in situations like this. And then the word contribution in Article 53b has to be interpreted in accordance with the directive. And therefore, they said for situations like this that since the ISP's services are used to commit an infringement, the ISP shall be considered contributing to the infringement in the way required by Article 53b. And therefore, they made it clear that it is also in Sweden possible to issue this kind of injunctions. But this was, as I said, or might not have mentioned, but this was not until 2017 we had this first case on this. Regarding the other conditions, there are, of course, focus on proportionality and the other aspect mentioned by Lord Justice Arnold. In this case, they looked at the interest of the right holders, the interest of the ISP, who, according to Swedish law, is the one who has to pay for the costs, and that is taken into account in the proportionality test. Look at freedom of information, of course, and the effectiveness and appropriateness of the measures. In this first case, the claim was concerning access to Pirate Bay and Svefilmer. The basis for the claim included quite a lot of movies. The websites in questions were found to contain almost exclusively infringing content, and the court found that blocking would at least make access more difficult, and there was no less intrusive action to avoid these infringements available. So the ISP was ordered to take measures within 14 days to prevent access to the services. They are a number of specified domain names, so the focus here was specified domain names. There was also a request for a more general injunction directed at the services as such, but that one was quite vague, and according to judgment by the court, both parties or all parties involved agreed that that might not be a suitable solution in this case. Furthermore, there was a request for blocking access to the IP addresses. That one was denied on the basis that the same IP address can provide access to several different services, and therefore there was the risk for overblocking was too extensive. The second case that became final was a judgment where a number of two publishers sued 6 ISPs, altogether covering something like 90% of the population in Sweden. This case was about scientific articles that were made available to the public without consent on Sci-Hub and Lidgen. This case, the Patent and Market Court basically followed the reasoning from the previous case I mentioned. Found that they were contributing in the sense of Article 53b of the copyright law. They did a similar proportionality test. There are several details in this judgment that I will not go into, but basically they concluded that most of the content here was infringing, and even the purpose of the services was said to give free access to articles protected by copyright. This order too was aimed at specific domain names or web pages. And the third case, Karin, the next speaker, will talk a bit more about this, but I will just say that this is, at least when you talk about the scope of the injunction, this is clearly the most interesting case. The case concerned the request of blocking users' access to Pirate Bay, as mentioned, and to different streaming sites, Nya Filmer and F-Movies. Both were found to mainly contain and be intended for infringing content. Here again, the proportionality test and the other conditions, the court followed the same reasoning as I mentioned previously. They added, however, that with reference to the UPC judgment from the European Court of Justice, that when the injunction is specified, for example, targeted on specific domain names, the consequences are taken into account already when the injunction is issued. So there is no need to provide the users with the possibility to assert the rights before the court once the implementing measures have been taken by the ISP. They also pointed out, the court also pointed out that the Swedish Post and Telecom Authority can act in accordance with another EU regulation if an ISP would take more extensive blocking measures than required. Yeah. I should also add that from the Swedish case law, it is clear that there is no need for the right holders to act against the infringer first. You can go straight to the ISP, just as in the UK. I think I'll stop there and give the floor to Karin, who will take over.
Thank you, Stefan. Karin?
Screen sharing. Kan jag är unmuted nu. Well, now we are all set. Thank you very much. Well, I will take on where Stefan ended and talk about the scope of blocking injunctions under Swedish law and elaborate on the scope as well as the structure of the blocking injunctions under Swedish law. And the scope of the blocking injunctions was clarified in the case mentioned by Stefan from this summer, where several film companies applied that Telia, one of the largest internet service providers in Sweden, should block its subscribers subscribers access to certain piracy sites, including the Pirate Bay. So the application more or less read as follows. The movie companies, they requested that the court should prohibit Telia from contributing to making available to the public certain film works that were listed in an appendix by technically blocking Telia subscribers' access to 3 large-scale copyright infringement services. For example, one of those were the Pirate Bay. First of all, through certain domain names that were listed in an appendix, and that was a traditional blocking injunction. I will get back to that. And secondly, through other domain names, which sole or predominant purpose is to enable or facilitate access to the infringement services in question, and of which Telia is informed by the movie companies from time to time, and that is the dynamic blocking injunction. I will get back to that as well. And the right holders, movie companies, they also requested that the injunction should apply provisionally. It was hence a request for an interim blocking injunction. And this case is groundbreaking in Sweden in several ways. First, and that might not be groundbreaking, and it was clarified already in 2017, as Stefan mentioned, in the B2 case, Bredbandsbolaget case, that an internet service provider may contribute to copyright infringement merely by providing internet access to its subscribers, and hence be ordered to block such access. But that was, as I said, already in the 2017 case established in Sweden. However, for the first time in Sweden, an interim blocking injunction was sought. And it was granted by the Patent and Market Court, but reversed by the Patent and Market Court of Appeal. Even more groundbreaking, I would say, is that the movie companies were granted a dynamic blocking injunction, both by the Patent and Market Court and by the Patent and Market Court of Appeal. So I will a little bit elaborate on the interim injunction. The first instance, the Patent and Market Court, they found that all criteria for an interim injunction were met, including the proportionality requirement. So the court issued an interim traditional blocking injunction. And they just ordered Telia to block access to a long list of domain names through the use of technical blocking means. However, the Patent and Market Court, they rejected the application for an interim dynamic injunction. In a preliminary assessment, a dynamic blocking injunction was not considered to meet the requirements that should be imposed on such an injunction. Such an injunction would leave it to the right holders to determine when a domain name is covered by the prohibition. And according to the court, it was not appropriate that an assessment by a private entity in this way could form the basis for an obligation to impose a fine under public law. As I will get back to, this opinion, this view was eventually changed by the Patent and Market Court when in their judgment, where they actually granted a final dynamic injunction. Telia appealed the decision, and in the next instance, the Patent and Market Court of Appeal, Telia claimed that some of the blocked domain names did not access any of the piracy sites, but led to other websites. And further, one of the previously illegal services had turned into an entirely legal website for movie reviews. And these claims by Telia were not rebutted by the movie companies. So with reference to the European Court of Justice judgment in the UPC cable case, the Patent and Market Court of Appeal concluded that a blocking injunction would lead to overblocking, thus blocking also of the legal content. And a blocking injunction would thus interfere with the internet user's right to information, and the requirement that an interim injunction must be proportional and strike a fair balance between fundamental rights was not met. And based on this, the Patent and Market Court of Appeal reversed the interim injunction. So I will now leave the interim blocking injunctions and instead discuss the scope and design of final blocking injunctions under Swedish law. And I will do that on the basis of the judgment in the Telia case from this summer. But before going into injunctions under the Swedish Copyright Act, I would like to mention two general principles in Swedish law with regard to injunctions. And that's regardless of whether injunctions are granted under the Copyright Act or any other legislation. First, an injunction must be clearly defined. The addressee must understand what to do or not to do in order to comply with the injunction. And if the injunction is subject to penalty of a fine, the addressee must understand how to avoid an obligation to pay such fine. Secondly, the court is not bound by the plaintiff's application. The court is, of course, not entitled to grant an injunction with a wider scope than the application, but the court is free to reformulate, specify, and limit a prohibition in relation to the application. Blocking injunction in Sweden is based on Article 53b in the Swedish Copyright Act. And as you see from the text, the court may issue an injunction prohibiting, on a penalty of a fine, a party that contributes to an act constituting an infringement to continue such act. And according to the article, or the article as such, does not mention the concrete measures to be adopted to comply with the prohibition to contribute to copyright infringement. So under Article 53b of the Swedish Copyright Act, the court may issue general or result-based injunctions under which the internet service provider may choose the measures to be adopted in order to comply with the prohibition. The internet service provider is obliged to achieve a particular result, but remains free to design the means to achieve such result. But the court is also free to issue a specified or approach-based injunction where the court specifies the measures to be adopted by the internet service provider in order to comply with the prohibition. And according to the Patent and Market Court of Appeal, blocking injunctions, at least in the case in question, should specify the measures that Telia should adopt in order to comply with the injunction. So the court argues that an approach-based injunction should apply. According to the court, such specification clarifies the injunction, which is in line with the general requirement that injunctions shall be clear in relation to the addressee. Furthermore, a specified blocking injunction ensures that the internet user's freedom of information is not unnecessarily limited. since the court, when specifying the measures to be adopted, may take the internet user's right to freedom of information into account, rather than leaving this to the internet service provider. So what kind of specification of the blocking injunction can we see in the Telia case and the Telia injunction? And as we will see soon, the injunction is specified in many aspects. But in order to avoid any misunderstanding, already the application for the injunction was rather specified. The specification that I will mention is thus not necessarily invented by the Patent and Market Court of Appeal, but rather a consequence of the movie company's application. Still, I think it's interesting to see how an injunction might be specified. So the injunction that was finally granted by the Patent and Market Court of Appeal read more or less as follows. Telia is prohibited under a penalty of 500,000 Swedish kronor to contribute to the unlawful making available to the public of the film works listed in Appendix 1 in such a way that Telia is required to prevent its subscribers through technical blocking measures from accessing the domain names listed in Appendix 2, the additional domain names which are primarily intended to provide access to any of the services, the Pirate Bay, Nya Filmer, and AF movies, as further defined in Appendix 3, and which one of the counterparties reports to Telia. Telia shall adopt technical blocking measures no later than 3 weeks after notification has been received, and the prohibition is valid for 3 years. So I will now go into the various specifications, and the first kind of specification is a specification with regard to the modes of exploitation and the works covered by the prohibition. And in the Telia case, Telia was prohibited to contribute to the unlawful making available to the public of certain film works that were listed in an appendix. And I don't know exactly how many film works that were listed in that appendix, but I believe it was approximately 50 to 100 works. All these 50 to 100 works listed had been proven to have been subject to infringement to which Telia had contributed. In other words, only these 50 to 100 film works were covered by the prohibition. In contrast, some countries may recognize catalog-wide or repertoire-wide injunctions that are injunctions to prevent further infringements of all rights of a right holder, or that are part of a right holder's repertoire or catalog. The injunction in such case is based on established infringements of a sample of those rights. Such a catalog-wide or repertoire-wide injunction was for sure not applied for by the movie companies in the Telia case. And I'm very doubtful that such catalog-wide or repertoire-wide injunctions would be applicable under Swedish law. Another specification of an injunction concerns the method to be used to prevent access to illegal content. And in the Telia injunction, Telia was required to block its subscribers' access to domain names through technical blocking measures. However, the blocking technology was not specified in the injunction, but was to be determined by Telia. Another type of specification concerns the domain names to be blocked. The Patent and Market Court divides the domain names to be blocked into two categories. First, there is a closed list of domain names that should be blocked. Secondly, there is an open category of additional or future domain names that may be used to access the piracy services. This is what we call the dynamic blocking injunction, and I will get back to that.
Sorry, we have just a few minutes left.
No problem. What? Skip that. Well, before going into the second category of the domain names, the open list, let me say something about the background to dynamic blocking injunctions. A condition for granting blocking injunctions is that they are effective. However, blocking measures are often circumvented by the persons behind the piracy sites. A traditional blocking injunction thus very often becomes meaningless shortly after the injunction, to the detriment of the right holder and the rights to protection of their copyright. And this is the reason why courts in several European countries for some time now have granted so-called dynamic blocking injunction. And in its guidance on certain aspects of the Enforcement Directive from 2017, the Commission defines dynamic blocking injunctions as injunctions which can be issued, for instance, in cases which material the same website becomes available immediately after issuing the injunction with a different IP address or URL, and which is drafted in a way that allows to cover the new IP address or URL without the need for a new judicial procedure to obtain a new injunction. So in this case, the use of dynamic blocking injunctions has been established also in Sweden. The Patent and Market Court of Appeal confirmed that dynamic injunctions fits within the provision in Article 53b of the Swedish Copyright Act, and also that they are proportional. And they noted that the argument put forward by Telia that blocking injunctions do not meet the criteria of effectiveness and therefore should not be granted actually speaks in favor of the application of dynamic injunctions rather than traditional injunctions, since a dynamic injunction is likely to increase the effectiveness of the injunction. So, which additional domain names may be subject to additional blocking measures? First of all, such additional domain names should primarily be intended to provide access to any of the services, the Pirate Bay, Nya Filmer, and F-movies. They must also access the services, the Pirate Bay, Nya Filmer, and F-movies, as further defined in an appendix. And finally, the movie companies must report the domain names to Telia. In this judgment, in this interim injunction, or in this injunction, the court also specifies the mechanism triggering additional blocking measures. So there is an advice or a mechanism that should be used by the parties in order to comply with the injunction. Finally, there is also a specification with regard to the injunction when it comes to the validity. The injunction is valid only for 3 years. So to sum up, dynamic blocking injunctions are now established under Swedish law, and it remains to see whether this will serve as a basis for cooperation agreements between the internet service providers and right owners, establishing a methodology that might be similar to that provided for in this injunction, the mechanism for triggering further blocking injunctions. Thank you.
Thank you so much, Karin, for your very interesting presentation. And we move forward to our last speaker for today, my colleague Eleonora Rosati, who is an associate professor in intellectual property law at Stockholm University and also the new director of IFIM. She will talk about direct liability of online platforms. Eleonora.
Yes, thank you very much, Frantzeska, and good afternoon, everyone. I would like to start, of course, by thanking you and the Stockholm Intellectual Property Law Review for the invite and the wonderful work that you have all been doing on this journal. The topic of my presentation, yes, relates to intermediaries, but I would like to place a special emphasis on a particular type of intermediary, that is hosting providers, or looking at the more sophisticated version thereof, what is come to be known as online platforms. And I would like to start by sharing a timeline of events which I hope might serve to put things in perspective. I would say that the topic of this presentation revolves around what has been occurring over the past 6 years or so. And in particular, the first development that comes to my mind is not a legislative development, but it is a judicial development. It is the decision of the Court of Justice of the European Union in Svensson, by the way, a Swedish referral to the court, asking about the treatment of linking under copyright law, and in particular the right of communication to the public in the InfoSoc directive. That was the first time in which the Court of Justice tried to enter into the realm of what Lord Justice Arnold referred to as accessory, indirect, secondary liability, that is to bring within the scope of the right of communication to the public activities that under certain national regimes had been considered as falling outside what EU law had harmonized, that is the conditions and requirements for primary liability. The following year, the European Commission, here we are coming to policy developments, unveiled its digital single market strategy. As you know, this strategy has led to a number of legislative developments, including the adoption last year of the DSM directive. So 2015 to 2019, 4 years of intense discussions, also revolving around the role, responsibilities and liabilities of online platforms. It is in the context of the directive that the provision contained in Article 17 has become part of EU law, and now it is for the member states to transpose this provision into their own laws. Then going back again to judicial developments in 2016 and in 2017, there have been some interesting decisions of the Court of Justice which have contributed to absorbing, if I may say so, concepts traditionally belonging to the unharmonized accessory liability regimes within the scope of direct liability under EU copyright. They are the decisions in GS Media, SIPLR, Ziggo, that is the Pirate Bay case. Then moving forward and reaching the end of this timeline, 2020, there have been, some interesting things to note in this year. The first one is the Advocate General opinion in the joined YouTube and Chiando cases, both pending before the Court of Justice. And in his opinion, last July, the Advocate General, Samsgard pardon my mispronunciation, tried to suggest that the approach that the Court of Justice had taken until now was not really correct, or perhaps people had been reading too much in these decisions, in particular those in GS Media, SIPLR, and Ziggo, and advised the Court of Justice to rule that platforms like YouTube and Uploader will not be directly liable under the regime as pre-existing the adoption of the DSM directive. Still, in the summer 2020, there has been the release of a study from the US Copyright Office addressing the question whether the US safe harbor regime is still fit for purpose, and the recommendation of the office has been in the negative. The safe harbor regime has fallen short of technological developments, and perhaps it is for Congress to update the legislative framework as introduced in 1998. And then the final development, which Frantzeska referred to in the opening of today's seminar, it is what is going on at the EU level. As you know, last week the European Commission released its IP action plan, and among other things, it announced something that we already knew, that is that a review of the safe harbor regime is on the table, and it is likely to be introduced in the Digital Service Act, which will be unveiled on the 15th of December, so in a few days' time. So clearly a timeline of events which have now restricted to 6 years, but clearly it is apparent that a lot has changed also from a technological standpoint. On this slide, you can see a comparison between how Amazon and YouTube looked like respectively when they were founded and how they look like today. Just by looking at the home page, it is apparent that these platforms have undergone an increasing sophistication of the services that they provide. And here I would like to share with you some quotes from these developments that I've highlighted, which show an increasing tension towards the divide, which is formally correct, between harmonized direct liability and unharmonized accessory liability regimes. And I think that the most striking of all still remains one of the opening paragraphs of Advocate General Spooner's opinion in the Pirate Bay case, in which he acknowledges that activities like those of the Pirate Bay, formally speaking, will not fall within the scope of application of EU law. They are a matter of accessory liability, and therefore they are a matter of national law. He's perfectly aware of that, but he also considers that a response that is formally accurate will not be substantially helpful. There is the need to provide a response at the EU level. And this makes me think also about the remarks by Lord Justice Arnold regarding the need for greater harmonization, which in this case, as in other instances, the CJU has not been shy on providing on its own right. Then there have been, of course, tensions regarding the correct interpretation of legislation. As you know, insofar as Article 17 of the DSM directive is concerned, there is a recital 64, which suggests that the regime introduced by Article 17 is not an innovation, but it is a simple clarification of the law as it pre-existed the DSM directive. As you know, also this is something that is subject to intense discussions and disagreements. Another example in the trademark field, which relates to the challenges of interpreting in a teleological way and in a dynamic way provisions that were introduced when things were very different. This is the opinion of Advocate General Campos in the Amazon case. The resulting judgment, I would say, is rather uninteresting because the CJU really did stick to the question asked, but if you read the opinion, there is an attempt by the Advocate General to draw parallels between copyright and trademark law, and suggesting that activities like those provided by Amazon under its fulfillment by Amazon service, which consist of the stocking and delivery of goods sold by sellers on the platform, might amount to direct trademark infringement if the goods that are being stocked and delivered are counterfeits. So a very interesting development. And then a reference to the US Copyright Office Section 512 study, which acknowledges how the safe harbor system is askew and perhaps is in need of update. Same thing insofar as the European Commission is concerned. If you read the action plan, there is a mention of the need to clarify, okay, this is a term that by now it is apparent is used very frequently, but also upgrade the responsibilities of online platforms and remove disincentives for their voluntary actions to address illegal content. So this suggests that the problems that we are seeing addressed are very similar and they are felt in similar ways at the judicial, policy, and potentially also legislative level. So let me elaborate a bit further by looking at the particular case of copyright. Here I have chosen a painting representing Hermes, which, as you will know, was the ancient Greek god who acted as messenger of the gods. Insofar as intermediaries are concerned, the refrain that we have heard for years is that intermediaries are simple messengers, and the old motto, "Don't shoot the messenger," also applies in this particular context. Probably this analogy and image is no longer accurate, because in the field of copyright we are seeing intermediaries being increasingly brought within the scope of application of liability rules, including by establishing direct liability. That certainly has been the case under Article 3 of the InfoSoc Directive, right of communication to the public, which, as you see the slide, is very difficult to decipher just by reading the text of the provision. And in fact, it has been for the CJU to try and make a sense of this complex but really topical economic right. And the Court of Justice has said that to have an act of communication to the public, you need an act of communication to a public. Thank you very much. This is very helpful. And indeed, the court has clarified this by looking into what indeed act of communication public do mean and what other non-autonomous interdependent criteria might also mean for the establishment of liability. And what is interesting in the context of the present discussion is the notion of act of communication. We now know from the case law of the CJU that there is no need for a transmission of a work. The simple accessibility thereof suffices. However, when that is the case, the CJU tells us that you need to look at whether the defendant performs an indispensable intervention. What does that mean? An intervention without which there is no possibility to access the work, or does it mean something a bit more relaxed? And in its case law, the CJU has indeed suggested that the latter is the correct approach. To have an indispensable intervention, you just need to see whether there is a facilitation on access. And that has been the case indeed in the Pirate Bay decision from 2017. The operators of the Pirate Bay do not perform any act of communication per se, any act of making available. They are not hosting and infringing content. They are just facilitating the commission of infringing acts. And according to the CJU, these activities of facilitation can qualify as direct acts of communication on its own right. And this is also supported by the fact that there is some optimization of the presentation of content, intervention, management of the content, removal of faulty links. And so all these activities contribute to a finding that the type of intervention performed by the operators of this platform qualifies as essential or indispensable, and therefore falls within the scope of application of Article 3 of the InfoSoc Directive. After this decision was issued, there were attempts, in my opinion, a bit misplaced, to provide a narrow reading of this decision. There were people who said, but of course, the Court of Justice said that Pirate Bay is directly liable. If nothing else, because if you call yourself a pirate, then don't be surprised you are treated like one. this reading, which might have had some merit, nonetheless also suggests an undue approach to the construction, which has been an expansive one, of the right of communication to the public. And indeed, there have been decisions across Europe in which the direct liability also of non-egregious platforms has been established. An example comes from Italy, where last year the Rome Court of First Instance found that the operators of Dailymotion, a platform that resembles YouTube, will be directly liable for the making available by users of the platform of copyright infringing content. Currently, there is this case that I refer to, the YouTube and uploader cases pending before the CJU. And this is a referral from Germany, the one in YouTube and both Elsevier are German referrals. And the question might be, how far can we stretch the Pirate Bay ruling? Does it apply also to cases like YouTube, at least insofar as the law existing before the DSM directive is concerned? But it would seem, quite natural to make this jump. It will not be too far-fetched. However, last July, Advocate General submitted the view that this jump will be inappropriate. Perhaps now YouTube and Uploader are liable under Article 17 of the DSM directive, but that was not the case prior to the adoption of this new piece of legislation. So under Article 3 of the InfoSoc directive, these subjects will not be directly liable. If you want to establish liability, you can do so, but that is a matter of national law. So this opinion is interesting because it adopts what I would call a regressive, in a neutral term, in a neutral way, view of the right of communication to the public. It is an attempt to bring back the scope of application of the right to where it was certainly prior to the decision in Svensson in 2014. So an attempt to revisit and possibly change also the case law of the CJU. As I mentioned, these joint cases are still pending, so it will be interesting to see what happens when the Court of Justice decides the referrals. What next then for hosting providers, platforms, intermediaries? As far as copyright is concerned, we do not have a clear-cut guidance that these subjects fall within the scope of application of Article 3 of the InfoSoc directive. It is not crystal clear whether they are directly liable or whether instead the CJU will follow the approach suggested by the Advocate General. Insofar as Article 17 is concerned, this is new law. It will need to be transposed by member states by 6 months or so from now. But at the same time, also there, the road is not completely devoid of obstacles. There is currently a case pending before the court in which Poland has challenged the very legality of Article 17. And there has been an hearing, and also that case will be decided in the next spring. Another issue is the nature of Article 17. Does it change the scope of application of Article 3 of the InfoSoc directive? Is it a new or even a sui generis type of right? How far can it go in its applications? And then another issue is that of safe harbors. Article 17 expressly excludes the availability of the safe harbors in relation to copyright infringing activities, but potentially allows them to remain available in other cases. According to the Advocate General in YouTube, the safe harbors apply irrespective of the type of liability. So this is a major headache that will likely need to be addressed at both the judicial and policy level. Indeed, in the context of the forthcoming Digital Service Act, which is something that does not happen in the void, because a discourse around platforms engagement, responsibilities and liabilities began quite a while ago in the copyright field with the discourse around Article 17, but also under the previous commission and its fighting illegal content document. Insofar as trademarks are concerned, and that will lead to my conclusion, we have had already one case decided in Belgium last year in which the direct liability of Amazon was established for the making available for sale through the platform of counterfeit Louboutin shoes. So coming to a conclusion, the analogy that I referred to about intermediaries being akin to messengers and the motto according to which you should not shoot the messenger has probably run its course. Things have changed also because these subjects have become increasingly sophisticated and probably no longer resemble the types of subjects that the legislator had in mind when it designs norms such as the Digital Millennium Copyright Act in the US, the Commerce Directive. So probably it is time to think of these online subjects as somehow different from simple intermediaries. And with this, I would like to thank you for your attention, and I will stop sharing my screen now.
Thank you very much, Eleonora. We have some time left for questions, and my colleague also Hellstadius has collected the questions during the session. So, the word to you.
Thank you all for your very interesting presentations. Now, the first question is posed to Lord Justice Arnold, and it is posed by Xavier, who says that Article 14 of the IPRED states that member states shall ensure that reasonable and proportionate legal costs and other expenses incurred by the successful party shall, as a general rule, be borne by the unsuccessful party unless equity does not allow this. Taking into account here that 14 IPRED does not refer to infringer, but to successful versus unsuccessful parties. In Carter versus Sky, why did the Court of Appeal not specifically mention Article 14 IPRED, even though it gave 5 main reasons for ordering ISPs to bear implementation costs? I'm sorry, Lord Justice Arnold, you need to unmute your microphone.
Sorry, I thought you would do that. Thank you. So I think the answer to that is straightforward, namely that Article 14 wasn't relied upon by the right holders in support of their argument. You might question the wisdom of that, but I think the explanation is fairly straightforward, namely that viewed from an English perspective, it would be hard to say that the ISPs were unsuccessful parties. Bear in mind that to the extent that they opposed the application, yes, they were unsuccessful parties with regard to the application, and they were made to pay the costs, and substantial costs as well. But you can test the proposition by considering what happens if it's an unopposed application. So there's no legal costs that are borne by the ISPs, and we're talking purely about implementation costs. So implementation costs don't fall within Article 14, because what Article 14 is talking about is your success or failure in the litigation. And yes, the ISPs pay if they are opposing the application and are unsuccessful, but if it's unopposed, there's no basis for saying that they're an unsuccessful party with regard to the litigation. And the question of implementation falls outside the scope of Article 14. So that, I think, is the reason why Article 14 wasn't relied upon by the right holders.
Thank you very much. I will follow this up with another question, first directed to you, Lord Justice Arnold. Do you envisage the web blocking regime in the UK to expand beyond copyright and trademark infringement and apply to other intellectual property rights?
Well, I explained in my talk that that's already happened. So the Nintendo case is an example of that. And it's a situation where it was accepted that the anti-circumvention measures were not intellectual property rights, although, as I pointed out, they might have argued differently. But nevertheless, that was not held to be a barrier. So it's very clear, first of all, that on an EU-wide basis, you can seek these website blocking orders on the basis of any intellectual property right. But secondly, at any rate within England, you can go wider than intellectual property rights and rely upon any legal rights that you may have.
Thank you. And I will continue with the same question for my Swedish, for the Swedish participants, Stefan Johansson and also Karin Cederlund. I will start with Stefan. Do you have any?
So, well, in Sweden, the legislation is exactly the same in all laws concerning intellectual property. So it's the same provisions for patents or trademarks or whatever it may be. So I think the question is mainly, do we foresee the same kind of infringements being committed with respect to other types of intellectual property? And don't know, but if they would show up, I'm quite convinced that you could use them in other areas too, because as I said, the legislation is the same.
And I have one follow-up now for Karin, because Lord Justice Arnold, he spoke about this need perhaps, or suggestion that more harmonization is needed at the European and in the international legal framework. And do you agree on this? And if you could choose, or what kind of measures do you see, Karin, as most important from the Swedish perspective?
For the harmonization or for the applicants?
I was thinking now from the applicants' side.
I think the most important is to have the contribution to the infringement stopped, and of course to have that as fast as possible and as efficient as possible. So I think it's important to, and it's a step forward that we have this dynamic blocking injunctions accepted in Sweden, because that for sure makes it more efficient. What I envisage is that there will be cooperation agreements in this regard, cooperation agreements that will facilitate a fast implementation and a fast blocking of sites. But that, of course, open up questions about the internet users and their rights to freedom of information, and because then we have two parties that will actually agree on something without taking into account the third party. But I think a fast and efficient blocking is what is important, if that was your question.
Yes, well, it is not my question, but from the participants, but that was actually my question. Okay, I will go back to Lord Justice Arnold, and we have a question here from Iyad. You mentioned that in your view, to assess proportionality without knowledge of the technical measures to be implemented is very, very difficult, and you saw that as an explanation for different outcomes in different countries. How much knowledge of technical details is needed in your opinion, and do the courts have the possibility to get this knowledge within the current system?
You are muted.
Try again. So it's a good question, and it helps to explain that as well as dealing with copyright and trademark and other intellectual property rights, I have a lot of experience in dealing with patent cases. And I started out in life as a scientist before I became a lawyer. And so I have the advantage that I'm used to dealing with technical cases and high technology evidence. Now, what has happened in the UK cases is that ever since the first one, we have had the benefit of expert evidence when necessary, explaining the technology involved. So go back to the first case, the 20th century Fox and BT case, the Newsbin 2 case. There was quite a lot of expert evidence put in as to the technology that was available for blocking. And so that was evidence that I was able to read and understand and take into account. And if you go back and look at my first judgment in that case, you'll see that there's a passage in the judgment which is discussing all the expert evidence about the technology. Likewise, when we come on to Cartier, there's some reference there to the expert evidence. And in the Premier League case, the first streaming server case, again, there's discussion of the expert evidence. So it is true to say that it puts a burden on the court because the court needs to understand the technology. However, I think this is important. After all, why should courts grant orders whose effects they don't understand? If courts grant orders whose effects they don't understand, then there's a severe risk of going wrong. And in particular, there's a risk of going wrong with regard to overblocking. And as everybody is now very well aware, one of the key requirements of proportionality is to ensure that any order that's granted is well targeted so as to avoid overblocking. But targeting depends on the technical means that you're employing. So how do you know whether your technical measures are going to be well targeted and avoid overblocking if you don't know what the technical measures are? So this is why I think it's absolutely fundamental. And I can understand that some courts would therefore take a cautious and risk-averse approach, because they might say to themselves, well, we don't know what technical measures are going to be implemented, and therefore we have to be very careful not to grant any order that will avoid a risk of overblocking, and therefore the answer is simply not to grant an order at all. Whereas my response would be to say, no, that's an abdication of responsibility. The correct answer is get to grips with the technology, understand it, and therefore know what technical measures can be employed, and therefore whether the use of the technical measures in this context will be targeted and will avoid overblocking. And then you can make the decision.
Thank you. We have time for 2 more questions. I will pose the same question to Stefan Johansson, actually. Do you agree with Lord Justice Arnold on that you have enough information about the technical methods?
Thank you. Yeah, I think it all comes down to, well, first of all, it is for the parties to present evidence on what is possible and not, or how complicated it will be and not. And then it is, of course, the obligation of the court to make sure it understands what is presented before it. But yeah, I think that's the short answer. Thanks.
Thank you. I have a question from Yolanda to Eleonora. What is your opinion about the draft guidelines of the European Commission on Article 17? Can they ask the CJEU to follow its position on the draft guidelines in the Polish case?
They can, but then it depends whether the court would accept them. And I think that there are 3 problems here. The first one is that indeed, as you write, they are still draft guidelines, so they've not been adopted yet. And secondly, and connected to this point, is that in this Polish challenge, the part of the Commission that is involved is not the copyright unit, which is in charge of drafting the guidelines, but rather it is the legal service. So they not necessarily share the same views on how copyright should be interpreted. And of course, it is the legal service that has participated in the hearing, which has already taken place. And then an additional point that I would like to flag is the legal value of these guidelines. Of course, the Commission is not a legislator, so this directive was not adopted by the Commission, was simply proposed by it. So it is not an authentic interpretation of the directive. And the other issue is the fact that as Article 17 itself clarifies, these guidelines concern the application of Article 17 and not its interpretation or its very existence. So they might be brought forward, but I doubt that they would carry decisive weight or even weight that would be considered at length by the CJU when it deliberates, or the Advocate General when he issues his opinion.
Thank you, Eleonora. So we have had a lot of questions that we couldn't post, but I will now say thank you to all of you who posed the questions, and I will leave the word back to Frantzeska.
Thank you very much. I will just thank our speakers for a fantastic session, very informative presentations, and our attendees, of course, for being here and participating in the seminar. Thank you very, very much. And I hope to see you soon again at one of the activities of the Stockholm IP Law Review. Don't forget to check our website on the 18th of December for our new last issue, the Christmas issue of the Stockholm IP Law Review. Thank you very, very much.
Thank you very much.
Bye.
Goodbye.
Bye.